Don't miss it. My name is Paul Barron. Welcome back into Tech Path. Let's just get started right into the clips today. This is the hearing that was happening. I loved it. Hearing entitled Dazed and Confused, breaking down the SEC's politicized approach to digital assets. This is pretty crazy. A couple of SEC formers in here with Michael Liftick, also Dan Gallagher, he's the Chief Legal Compliance Officer over at Robinhood. You also have Fasaro in there from Bitwise. So there's a pretty good group in here. And then as usual, we have the naysayers, and that's going to come to us today in today's movie, coming over from the lecturing fellow from Duke, Mr. Lee Rayner. So let's go over to the first video, take a look, and you'll kind of get a framework. Take a look.
I come before you as someone who worked at the SEC, respects the agency, and believes in its mission. This approach has stifled innovation, caused companies to move offshore, and ultimately harms U.S. consumers' ability to engage reliably with the industry.
My name is Dan Gallagher, and I'm Chief Legal Compliance and Corporate Affairs Officer at Robinhood Markets, Inc. And I served as an SEC Commissioner and Deputy and Co-Acting Director of the SEC's Division of Trading and Markets. Unfortunately, the current commission instead wistfully calls on the cryptocurrency platforms and token issuers to come in and register. Robinhood did, and for all our efforts in return, Robinhood received a Wells notice.
What message does that send to startups, to developers who want to bring their products into the United States?
Well, I think the message is clear. The message is go away. Find somewhere else to do this. The United States is not welcoming.
My name is Teddy Fasaro, and I am the president of Bitwise Asset Management. We also believe that the approval of Bitcoin ETFs came too late. We believe that investors will benefit if many more digital assets are approved for trading and listing in such a manner.
We've already seen Robinhood really have a fairly good success in the EU and continuing to launch products over there. So it's striking to me that we have to continuously re-represent that very case of innovation is moving away. This is a problem in the US. I get some that, some of these lawmakers may not be fully aware of this, but it's kind of interesting to see this. Now, what I want to go to next is Lee Rayner. He's talking about the potential or the component of no adoption and no use case. Listen to what he had to say.
The crypto industry has resorted to narratives and aggressive lobbying because it has yet to produce a product or service that provides genuine economic utility to most Americans. But the reality is that very few Americans own or use crypto. And among those that do, there's no evidence to suggest that their vote is principally influenced by a candidate's stance on cryptocurrency.
Bitcoin's been around since 2009, so it's been 15 years. And you look at most other technological innovations, usually they have a huge adoption, and that has not happened in crypto.
Consumer demand for spot Bitcoin ETPs has been nothing short of remarkable. They've taken in net inflows of over $16 billion this year. That is the most successful exchange-traded product launch of all time. Top 25 fastest growing ETPs of all time.
I think, as usual, it shows that Congress is not doing their homework. They continue to not understand where the market is going. And many things that break down within that, the years in time that it takes to get a technological advancement, really global. I think what we've seen with Bitcoin has been already accelerated. But if you look at Web3 and a lot of the projects that are really driving blockchain usage as a whole, most of those are less than 5 years old. And this technology is still evolving, so it's very similar to the early stages of the internet. And I'll go to this next clip, and this is getting into the SEC talking about their case performance, how they've been doing. Listen in.
Which of any of these actions can any of you point to that you have discovered were absolutely wrong, that the facts were not correct? Which one would you point out that the SEC was involved with settling was wrong?
I'll go first, Congresswoman, and I'm assuming my fellow panelists would disagree with me on this. So, I can't really identify any. Of course, sort of the one notable partial loss in the SEC's track record, of course, is the Ripple case. My testimony reveals that the SEC is simply doing the job Congress tasked it with. They have no basis to be mad at the SEC for enforcing them. To paraphrase Matthew McConaughey's character in Dazed and Confused, that's what I love about these federal securities laws, man. I get older, they stay the same age.
Mr. Reiners, I hope no one's listening to you about this market, especially as a student trying to understand the space. Frankly, the idea that you could point out that there's only one time that the SEC was even partially wrong has to be willful ignorance. I mean, I don't know how it could be anything other than deceit. It's hard for me to understand, because on August 29th, 2023, the Circuit Court upheld the position that the SEC violated the Administrative Procedures Act when it denied Grayscale's application to convert Grayscale Bitcoin Trust into a Bitcoin ETP. It was a pure rebuke. Lawyers would normally get disbarred for the conduct of SEC in the debt box case. So there are lots of cases where they've been caught and told that they were wrong by the courts.
So it's important to note that the SEC is, in my opinion, doing their job as a cop on the beat. But with crypto, it's very hard.
The law is the law, and the SEC is right to protect investors when you break it. Thank you, and I yield back.
But in my opening statement, I referenced the legal faceplants the commission has repeatedly had before federal courts.
All right, I like that last statement. Legal faceplants for sure has been the case, and the SEC has been a continuous losing streak in terms of digital assets and their position upon them. Here's Stuart Alderati talking a little bit about this. The SEC finally admitting their, number one, their crypto asset security statement is a made-up term, and number two, to prove a crypto asset security is an investment contract, the SEC needs evidence of a bundle of contracts. Obviously, none of that has ever happened. So continuous, and we've shown this and talked about this quite a bit before. It continues to show, I think, the position of the overreach that we've continued to see coming out of the SEC itself. Now, I want to go over to this other clip because we're going to get into another layup here, I think, from Richie Torres. And I love this one. Let's take a look.
Does the term digital asset security appear anywhere in any rule promulgated by the SEC?
No, sir.
Did the SEC invent the term out of thin air?
They certainly created it.
In a recent court filing, the SEC apologized for using the term
Correct.
digital asset security because it's misleading. Is that correct?
I saw that, yes. Found it a very odd, admission by the commission that they've been using this term, basically out of thin air. And if you recall, the judicial decision in the Ripple case said that secondary market transactions do not give rise to investment contracts.
Is this simply an argument for us to pass FIT 21?
Well, I think you need to pass FIT 21.
Regardless, because I think, yes, there's many arguments around FIT 21, and I think that is going to be the big setup for Congress, whether it happens in this next session or if it happens in early 2025, we'll find out. But I think we're going to see a landslide of crypto regulation starting to make its way through. Now, of course, there's always got to be the naysayers that kind of support the guys that don't know what they're talking about, especially when you look at what was going on in this particular hearing. And it's always the same guy. It never fails. So we have to introduce Mr. Sherman.
It works for soups. It works for nuts. It works for bonds. It works for stocks. Mr. Reiners, does the American court system work?
Yes.
That's an easy answer. Okay. Let's see. Would any of you support legislation that would just eliminate this whole controversy and just declare that crypto is a security? If you're in favor of such legislation, please raise your hand. I'll point out that one witness raised his hand.
These people. I don't understand this anymore. It's chaos. It's chaos up there. Wiley Nickel, of course, had some statements he wanted to add in. We're going to hopefully have Wiley on, Mr. Nickel, I should say, on the show here very soon. And he talks about SAB 121. Listen in.
Can you provide us with some insight as to why the SEC would approach SAB 121 in this manner, and what's the impact of this confusing approach?
Unfortunately, I can't provide much insight as to why the SEC is proceeding this way because it is confusing. What we're left with is, quote, non-binding staff guidance in the form of SAB 121 that has been updated by a non-binding staff speech that suggests that there may be exceptions to SAB 121, as well as one-off conversations with the SEC staff. This is not clear at all.
Correct me if I'm wrong, did FTX put custodial assets on its own balance sheet?
I believe so.
Yeah.
At least there were a lot of.
Isn't that ironic that SAB 121 contains a cruel irony that it's asking banks to do what FTX did, which is put custodial assets on its own balance sheet?
All right, so you can kind of see there's a lot of confusion in this whole idea around how the SEC is trying to articulate many of these rules and laws and legislative tracks that they've been continuously peppering the industry with. So the fact, I think, is now that Congress is maybe educated enough to where they've just kind of thrown their hands up and said, yes, clearly we have a rogue entity out there in the SEC, and we're going to get that stopped, hopefully with some legislation, because I think that's going to be the only way it takes case. And with that, there's, of course, some other scenarios that are playing out right now in the NFT space. And it may open up some opportunity here, so take a look.
On August 28th, OpenSea, one of the leading NFT marketplaces, received a Wells notice from the SEC threatening to sue the firm for hosting unregistered securities on their platform. And on Monday, Flyfish Club settled with the SEC for over $750,000 for an NFT offering that simply allowed for exclusive restaurant access. In these cases, did the SEC articulate a standard that they employ to determine whether the sale of an NFT is considered a securities transaction?
The challenge is that we consistently analogize to Pokemon cards, collectibles, whether it's arts or watches or baseball cards, and we've not heard a compelling response to that out of the SEC.
When Mr. Gensler was testifying before the Financial Services Committee, I asked him whether the sale of a Pokemon card constitutes a security transaction, and he said no. I then asked him whether the sale of a Pokemon card via the blockchain, whether that constitutes a security transaction, and he equivocated. The value of a Pokemon card does not depend on a Pokemon corporation.
That's
right.
correct.
It's a collectible.
That's
okay. Right. I'm done. Thank you.
My proposed legislation, the New Frontiers in Technology Act, seeks to address Chair Gensler's unjustified assault on non-financial NFTs by exempting them from securities regulations.
So that's going to be a big one, and it is on the agenda there that they were talking about today. Here's his bill that's coming in. He's going to be proposing that, Mr. Timmons, New Frontiers in Technology NFT Act. Maybe we get a little bit of a head run on what's happening in MiCA and in the EU, but unlikely with the speed in which Congress addresses these things. Of course, all this is still up in the air, but I do think we are getting some attention in a big way. And of course, the key here is having lawmakers that actually care about Americans, care about companies and innovation and jobs, and can execute on their job in Congress to get it done. I'll leave with this last clip.
How are you a crypto attorney?
I am a securities lawyer.
How are you related to crypto? Are you advocating for Robinhood? Is that what you're doing?
Yes, Ranking Member Waters. I'm here on behalf of Robinhood.
Robinhood is attempting to get, license for crypto?
We were Ranking Member for a good part of 2022 and into 2023.
So has Robinhood been turned down, turned back?
Correct.
Why?
I don't have the rationale. We didn't get an explanation. We just got a stop sign.
That's odd. You don't know why your client was not licensed. Teddy Fusero, how are you involved with crypto?
I'm the president of a digital asset and cryptocurrency asset management firm.
Do you believe there needs to be serious guardrails with crypto to protect the investors?
We do, and we think that the exchange-traded product or exchange-traded fund provides a lot of those benefits.
So do you agree with any of the actions that have been taken, or you disagree specifically with any of the actions?
I don't agree or disagree with any of the specific actions you mentioned. I'm not a lawyer or a specialist on enforcement actions.
Thank you very much.
Okay.
I yield back the balance of my time.
Yeah, so that's good. I think term limits are now and should be in order for situations like this. I mean, you've got to be able to do the research and really understand what's happening within these things to really make a difference, because these are real serious issues that need to be addressed by Congress. We'll continue to cover this and much more. A lot is happening this week. Of course, we got things with Oh gosh, it's a Solana break point. We've got the Fed decision coming out, just came out. So be on the look here. If you guys are not in the Diamond Circle, get in right now. We always leave a link down below. Catch me on X at Paul Barron. We'll catch you next time right here on TechPath.